legislate everything, but you cannot legislate this. Stateless death, stay out of it. Stateless death, it isn't yours. The one thing that falls outside your walls was always mine before.
Hey everybody, so I'm going to be reviewing an article that I just posted on Substack. It's called "The American Associations Were Against the Right to a Stateless Death." Let's see if there's anybody here. All right. I didn't post it in the description, but once I'm done with this live stream, I'm going to go back and do that so you guys can read it if you're interested. The American medical associations were against the right to a stateless death. How a private guild manufactured a crime, captured the state, and made you beg for a liberty you always had. Stateless death. The phrase does not yet exist in our political vocabulary. It should. Not death administered by the state, not death permitted by the state, not death that requires the blessing of a licensing board, a legislative chamber, or a guild of credentialed gatekeepers. Death as it existed before any of those institutions claimed authority over it as a private act between human beings, unmediated by government. The modern debate over assisted suicide is conducted almost entirely on false. Advocates are told they're asking for a new right, a special dispensation of the state did not previously recognize. Opponents insist the law has always forbidden this. Both sides accept a premise the historical record does not support. The historical record is more damning than either side acknowledges. The laws forbidding assisted death were not the natural state of affairs. They were manufactured deliberately, strategically, and the direct financial interests of a private organization by the American Medical Association, and the state licensing apparatus is spent decades constructing. Before the AMA, before state medical boards existed, before the licensing regime now governing medicine was assembled, people helped each other die. There were no statutes against it because there was no need for statutes. It was a natural human act predating the state entirely. What advocates today call decriminalization is nothing more than a demand to be restored to the condition that existed before a guild rewrote the law in its own interest. To understand how we got here, you must understand what occupational licensing actually is, how it was constructed, and most importantly, who it was built to serve, the founding of a monopoly. The American Medical Association was founded in 1847. Its stated purpose was to elevate medical education. Its actual purpose, as its own record may explain, was to eliminate competition. In the mid-19th century, American medicine was genuinely competitive. Homeopaths, herbalists, osteopaths, midwives, and allopathic physicians all practiced and competed for patients. None held a legal monopoly. The AMA's founder, allopathic university-trained physicians, found this arrangement intolerable. They could not win outright in a free market, so they went to the state. Milton Friedman diagnosed this pattern precisely in Capitalism and Freedom. The pressure to license an occupation rarely comes from members of the public who have been harmed by members of the occupation. On the contrary, the pressure invariably comes from members of the occupation itself. Friedman chose medicine as his primary case study, the strongest possible public interest argument for licensing, and concluded that even there, licensing primary function was restricting competition and concentrating power, not protecting patients. Paul Starr, in his Pulitzer Prize-winning The Social Transformation of American Medicine, documents the mechanism in detail. The AMA's strategy was to capture the state licensing apparatus, to lobby legislatures into requiring licenses, to get licensing board staff with AMA-aligned physicians, and then use those boards to define legitimate medicine as AMA medicine while excluding everyone else. Starr describes professional credentials as the means of legitimating professional authority, achieving solidarity among practitioners, and granting a monopoly from the state. This was not medicine advocating, this was not medicine advancing the public interest. This was a guild seeking a government enforced monopoly, and with remarkable patience and political skill getting one. The Flexner Report, Convert Ammunition. In 1904, the AMA had created its Council on Medical Education, an internal body whose explicit goal was to reconstruct American medical education and reduce the number of practicing physicians. The council had a problem. Any direct AMA lobbying campaign to close medical schools would be recognized immediately as the self-interested power grab it was. So they did something more sophisticated. They laundered the agenda through a prestigious third party. The AMA's Council on Medical Education was the Carnegie Foundation for the Advancement of Teaching and asked them to commission an independent study of American medical schools. The study was funded covertly by the AMA. Carnegie Foundation President Henry S. Pritchett made the arrangement explicit in a private memo to the AMA Council head, author Dean Biven, MD. When our report comes out, it is going to be ammunition in your hands. It is desirable, therefore, to maintain, in the meantime, a position which does not intimate an immediate connection between our two efforts. The man chosen to write the report was Abraham Flexner, not a physician but an educator, and conveniently the brother of Simon Flexner, head of the Rockefeller Institute for Medical Research. The report was presented to state legislatures and the public as an independent philanthropic assessment. It was precisely the ammunition Pritchett had promised. Published in 1910, the report recommended exactly what the AMA's council had wanted. Most medical schools should be closed. State licensing boards should issue licenses only to graduates of AMA accredited institutions, and surviving schools should adhere strictly to the AMA model of medical education. Cat states when a guild became the law. The AMA then carried the Flexner report to state legislatures across the country and lobbied for its implementation. State governments complied readily, in part because state medical boards were already staffed with AMA aligned physicians who had every professional and financial incentive to adopt the report's recommendations. The results were swift and total. In 1904, before the report, there were 160 medical schools in the United States with more than 28,000 students. By 1920, there were 85. By 1935, only 66. Over half of all American medical schools closed or merged within 25 years. The supply of physicians fell sharply, which not coincidentally drove physician income substantially upward. In 1912, the Federation of State Medical Boards was formally created, unifying the AMA's Council on Medical Education with state licensing bodies under a single national framework. The Federation agreed to use AMA's academic standards as the basis for accreditation, giving the AMA's decision in Starr's words the force of law. A private guild now wielded the coercive authority of the state, not as a government not as a government agency, but as the organization whose standards government had agreed to enforce. The human cost was not incidental. 5 of the 7 medical schools established to train African American physicians were closed. All but one established to train women was eliminated. The people excluded from medicine by this consolidation were not excluded because they were incompetent. They were excluded because they were competition. From medical monopoly to criminal law, with the licensing apparatus in place, the AMA had achieved something extraordinary. It had become the de facto authority on what medicine was permitted to do. State legislatures that had spent decades deferring to the AMA on questions of education now deferred to it on questions of ethics and law. It was in this context that the AMA's opposition to assisted death became a legislative force rather than merely an institutional preference. In 1885, the AMA formally declared its opposition to voluntary euthanasia. As pharmaceutical technology advanced and morphine and chloroform made painless death increasingly practicable, some physicians began openly advocating for assisted death as standard end of life care. The AMA moved against it. Their ethics code declared physician assisted suicide fundamentally inconsistent with the physician's role as healer. Notice what this declaration accomplished. It allowed a private organization with no direct government authority to define the outer limits of what licensed physicians were permitted to do. And because state licensing boards now enforce AMA standards, a physician who assisted a death risked losing the very license the AMA's lobbying had made legally mandatory. The AMA's opposition was not abstract ethics. It was enforced through the licensing mechanism the AMA has spent decades building. When state legislatures moved to codify this prohibition into criminal statutes, responding to early legislation campaigns such as the Ohio and Iowa proposals of 1906, the AMA's institutional position gave legislatures their ready made justification. The medical establishment had spoken. Legislatures who knew nothing about medicine deferred to those who claimed to. When a question reached the Supreme Court in 1997 in Washington versus Glucksberg, the AML filed an amicus brief arguing that criminal prohibitions on assisted suicide were constitutional. The court agreed, explicitly citing the protection of medical ethics as a legitimate state interest justifying criminalization. A private guild, self interested ethical code had been formally laundered into a constitutional state interest. The architecture of the monopoly was now complete. The AMA had lobbied states into creating licensing boards, staffed those boards with its own members, used those boards to enforce its ethics codes, and then had the ethics code ratified by the Supreme Court of the United States. The Guild was not speaking for doctors. At every stage of this history, it's worth asking who exactly was the AMA representing? Not the public. The public demanded medical licensing. The AMA lobbied states to impose it, not patients. Patients seeking compassionate end of life care did not ask the AMA to criminalize it. Not even doctors. A 2016 Medscape survey found that 57% of physicians support physician assisted dying. A 2011 survey found that 77% of physicians believe the AMA no longer reflects their views. By 2018, 10 state AMA chapters, including California, Oregon, and Washington, where legalization had become reality, broke from the national organization entirely and adopted neutral positions. The AMA represents the AMA. It represents the institutional interests of an organization that built its power by capturing state licensing boards, eliminating competition, restricting the supply of physicians, and maintaining authority over what medicine is permitted to be. Its opposition to assisted death was always primarily about protecting that authority, not about protecting patients. Reclaiming the stateless death. Here is the argument that is almost never made directly, but which the evidence demands. The right to a stateless death, the right to receive or provide assistance in dying without state permission, without a licensed intermediary, without bureaucratic review, is not a new right. It is an original condition. It predates the AMA. It predates state medical licensing. It predates every statute now. It predates every statute that now criminalizes it. Before the AMA's lobbying constructed the medical licensing regime, before the Flexner report gave the regime its scientific veneer, before state boards adopted AMA standards as law, people helped each other die. No license was required. No statute forbade it. The state had no claim over it because it had not yet granted the state that claim. What occupation what occupational licensing does. What it has always done in every field it touches is convert natural human activities into regulated privileges. It places those activities behind a gate, hands the keys to a private organization with its own financial and institutional interests, and then when ordinary people want to do what human beings have always done for one another, tells them they must petition the state for permission, the same state whose laws were written at the direction of the guild. This is the fraud at the center of the modern debate. Decriminalization advocates are framed as demanding something new. They are not. They are demanding to be returned to the condition that existed before a guild manufactured a crime, before a private organization acting in its own interest used the coercive power of the state to place a natural human liberty behind a gate it controlled. Friedman saw with this logic. He wrote that the overthrow of the medieval guild system was an indispensable early step in the rise of freedom in the Western world, and that modern occupational licensing had reconstructed that guild system in contemporary form. Medical licensing is that system. The criminalization of assisted death is one of its products. A stateless death does not require anyone's permission. It only requires what it always required before the American Medical Association intervened. Two human beings, a private contract, and the absence of a state that has been convinced it has the right to stand between them. The state did not create this right, it cannot grant it. It can only acknowledge what it took, which was taken illegitimately.